if a man puts out another man's eye, his eye too shall be taken out. An eye for an eye. Where does it come from? It's in the Bible, of course, but before it was in the Bible, it was in the Law Code of Hammurabi, one of the earliest written law codes to survive. In this lecture, we'll explore the very beginnings of written law and the principles of justice that it contains. The earliest written law codes come from Mesopotamia, the ancient Near East, the land between the rivers, the Tigris and the Euphrates rivers, which were the cradle of civilization. Human civilization is thousands of years old. Humans invented agriculture, something like 10 to 12,000 years ago. And agriculture was the foundation for large and complex states, for societies that had complex forms of social organization and permanent institutions, permanent forms of authority and power. Now, long before humans formed states, they lived together in societies. And those early human societies had their versions of laws. They had customs. But the change to agriculture and the rise of states, and especially the rise of complex states like those in ancient Mesopotamia, meant that laws could be made, rules that were enforced by the state. The earliest written law codes that we know of go back to the 3rd millennium BC. The Code of Ur-Nammu dates to 2100 BC, but it's largely fragmentary. The more famous, and justly famous, Law Code of Hammurabi dates back to around 1780 BC. That is, that it is written as long before the birth of Christ, as Benjamin Franklin say, is after the birth of Christ. It's the law code of the king Hammurabi, king of Babylonia, one of the early civilizations between the rivers in the Near East. And the law code of Hammurabi preserves for us our earliest written evidence for a large-scale legal code. And writing is an important part of this because law, written law, requires one of the great technological innovations in all of human history, writing itself. Forms of putting down ideas and words into permanent form. And it's in ancient Mesopotamia that both large-scale state societies and writing are invented. And it's because of these great inventions that we're able to witness the earliest law codes that are known to us, law codes like the Code of Hammurabi. The Code of Hammurabi was found at the beginning of the 20th century by a French archaeologist who was exploring in what's now Iran. And he came upon the remains of the city of Susa, where was preserved on a giant stele the Law Code of Hammurabi, an astonishing collection of laws that date back to the 18th century BC and preserve over 280 laws that were enforced in this society. The laws are enforced by Hammurabi, who declares in a prologue to his law code to be chosen by the god Marduk to be king of the Babylonians. And he announces that he is promulgating this law code in order to protect the justice of the oppressed. And in fact, this is a recurrent theme throughout the history of law, that law should be just. And it's distinctly important that in this law code, it is enacted in the name of the oppressed. Here you have a king who is claiming to seek justice by enacting a code of laws that protect the oppressed. And it's a remarkable series of over 280 laws that include rules for procedure, rules for contracts, rules for family law, that include corrective justice, to use Aristotle's terms, that include rules like an eye for an eye, a bone for a bone. This is a legal principle called lex talionis, an eye for an eye. The principle that the punishment should fit the crime in a literal and exact sense. An idea that corrective justice should inflict on the wrongdoer a punishment that is precisely and literally equal to the wrongdoing that he has perpetrated. An eye for an eye is embodied in this set of legal codes. But you'll also see other kinds of laws, corrective laws like an eye for an eye, but also rules that we would consider to be about liability. And in fact, this is one of the most interesting parts of the entire legal code of Hammurabi. what is really a primitive law of liability. Liability is actually a complex type of problem because it means that someone is responsible for something that they necessarily didn't intend to happen. Liability, which is closely connected with the concept of negligence, means that someone has behaved in a way that makes them deserving of some kind of penalty or punishment or retribution for something that they have done, even if they didn't intend the outcome that happened. And the specific example that's given in the Law Code of Hammurabi involves a goring ox. Now, you may not have known it, but some of the most sophisticated legal principles in all of human history arose out of the problem of goring oxes. Well, what is a goring ox, you ask? A goring ox is an ox that gores, an ox that's given to the problem of goring. It's not a problem we face in our society, but in ancient Babylonian society, which was an agricultural society, it must have been quite a serious problem because the Law Code of Hammurabi says that if you have a goring ox that you don't fence and it gores your neighbor's oxen, then you are liable. You are responsible for retribution. In other words, it says, imagine this. There are situations in the world that will happen against or despite anyone's intention. Sometimes accidents occur, and no one is responsible. However, sometimes events occur for which someone must be held responsible. So if you have a goring ox, an ox that you know is liable to tear out the insides of your neighbor's oxen, and you don't take action to restrain that ox, then you are liable, you are responsible, you are negligent if you don't. And this is already enshrined in the Law Code of Hammurabi.